Really, I covered three areas of damages. The first was I took people through the customary international law framework for damages at international law and tried to explain when the situation arises where you can claim loss. And I focused in particular on the importance of proving that you have suffered a loss, so the causal link, causation, which is a very interesting issue. And then the other two parts of the damages analysis I looked at were the emerging areas, which were contributory fault, which is a familiar concept to many of us, but is just starting to take hold in investor-state arbitration, and we're seeing some decisions come through with some element of that now, 2 or 3 in the last few years that are quite interesting. And the final point I looked at was moral damages, which for the same reason, it's coming through now in some of the more recent decisions, and there was a concern I identified about whether or not that was developing in a principled way, and I flagged the concern and said that I think we had to be very careful with these new emerging areas to make sure they develop in a principled fashion so that they are applied properly. So those were the three areas of damages I dealt with. The second part of the presentation dealt with interest and costs, which are often left off as an afterthought, but are actually quite important areas, especially for practitioners and clients, can have a very significant impact on your total amount of loss. And I just ran through the basic framework and highlighted a couple of trends that are coming through in tribunal decisions where we can see them, so that I could show the audience, look, if you are arguing about these issues, this is the way that the majority of tribunals are now looking at these issues, and this is the way they're ruling.
One of the very interesting issues that has arisen, and it's also a very difficult issue, is the last-minute change of counsel or last-minute introduction of new counsel with a view to disqualifying a member or members of the arbitral tribunal. Now, that is an issue that has arisen on a number of occasions, sometimes very clearly motivated by bad faith. And I think the arbitral tribunals have generally handled these issues very well. In some cases, they've actually gone to the extent of disqualifying the new counsel from acting for the party concerned. The other issues are your usual issues of witness preparation, document production, and so on and so forth.
Well, just to explain where I'm coming from, in the forthcoming Transatlantic Trade and Investment Partnership Agreement that's currently being negotiated between the EU and the US, the EU has made a significant move not to include investor-state arbitration, but have proposed an investment court that will see arbitrators replaced by publicly appointed judges and will have an appeals mechanism. Now, why is this relevant to Asia? Because if the EU is going to propose this in agreement with the US, then what's to stop it doing so in trade agreements with Asia? And in fact, those familiar with the free trade agreement currently being negotiated between the EU and Vietnam will know that actually Vietnam has also agreed to the investment court being included in that agreement. Now, the EU and Singapore free trade agreement hasn't included an investment court proposal and does include investor-state arbitration, but there are wide powers potentially for the later inclusion of an investment court. We'll just have to wait to see what goes ahead with free trade agreements that the EU is currently negotiating with other Asian countries like Malaysia, the Philippines, Japan. But let's hope the fact that the US in the Trans-Pacific Partnership Agreement hasn't agreed to an investment court, and in that agreement includes investor-state arbitration. Let's hope they won't agree to the EU's proposals for the TTIP.
A few reasons for it. I think investment arbitration is actually a growing field, and Asian parties, as you can see, discussed in the conference, it's a fact that many bilateral agreements and multilateral agreements are containing ISDS provisions, and investment arbitration is the way that in the future will be disputes will be resolved by way of investment arbitration. And it's timely that we have to educate. That's one. Two is also discuss all the current issues that are related to it. So I think that's the reason why we organize it, to actually first create awareness. Secondly, actually let people know that there are experts in this area who are dealing with it. I think that there is interest now, and what will happen is that there will be more and more parties coming from Asia, and that will actually create a need for arbitration centers and hearing venues instead of being held in Washington to come to this region. So the geographic proximity is very important. The other thing is the cultural affinity that need to be handled when you have investment arbitrations. So I think once parties realize that these are very large disputes involving their countries, their sovereign rights, so perhaps what they will do is that they will start to actually say that we want to locate it in Asia. So I think we are ready for that. So the center has two large hearing rooms which can sit 50 persons with full facilities, recording facilities and translation facilities. So in that way, we are preparing for the possible hearing of cases in Asia itself.
A state is held responsible for a state-owned enterprise. Usually, three factors are taken into account. This is with regards to the structure, the function, and the control. Looking first at the first factor, structure, here the issue is whether or not an SOE is an organ of the state. The term organ is used in its broadest possible sense. It is not limited to higher levels of government. Neither is it limited to persons representing the state with regards to foreign entities. And it is also not limited to state-owned enterprises of any particular type. Instead, the term encompasses entities of whatever function, whatever classification, and wherever they are in the hierarchy. Moving on to the second factor, which is function. Here, the key thing is that they must be engaged in performing some sort of governmental authority. The term governmental authority itself is not defined by the International Law Commission. However, the Commission has suggested that beyond a certain limit, what needs to be considered is the traditions of a particular country as well as its history. This is a very subjective approach. An alternative to the Commission's approach would be to look at the question objectively and to have regard to what is considered governmental authority in a modern setting. Apart from this, we move on to the third factor, which is control. In the context of control, it has to be shown as a matter of fact that an SOE was acting under the directions, instructions, or control of a state. In this regard, it cannot be simply the case that an SOE was generally acting under the instructions, direction, or control of the state. Instead, it must be shown that with regards to the particular act of the SOE that is being complained of, there were specific instructions or directions from the state. This naturally leads to the question, what happens if the SOE's conduct has gone beyond, in some way, the instructions given by the state? On the one hand, if it is merely incidental to the instructions given by the state, then I would think that the state would be responsible. However, as you would appreciate, if it has gone entirely beyond what has been directed by the state, then the state would logically not be responsible. Finally, I must impress upon you that in this context, directions, instructions, and control are three separate requirements. So if any one of them are met, the state will be responsible. Similarly, with regards to the three broad factors of structure, function, and control, in my view, these are also disjunctive, so that if any one of them are met, then the state would be responsible for the SOE.
Well, the rules on transparency are important for states because it enhances the legitimacy and accountability of the process. It's also a sign of good governance and of fight against corruption. It will allow also states to justify when they have to pay damages, for instance, and they have to justify that expense within their parliaments. It's also good for people and for practitioners and for legal education because it gives access to several aspects of the dispute, of the proceedings, of the arbitral award, of the experts. It gives access to hearings. So it will kind of introduce a little bit of the principles of open justice to ISDS. And I think if people can recognize how the procedure is going and can understand how the proceedings are being conducted, that will add legitimacy to the process.